If you're about to walk into family dispute resolution in Australia without knowing what happens in that room, you're about to make mistakes that will cost you months of your life. Most people think mediation is just a conversation where the mediator tells them what's fair. Wrong. That mindset is why 40% of FDR sessions fail. They show up unprepared, negotiate from emotion, and walk out with nothing. After preparing hundreds of parents for FDR, I can predict within 10 minutes who walk out with an agreement and who waste the session. The difference? Preparation. The unprepared make 3 mistakes. They negotiate from emotion, have no boundaries between needs and wants, and don't document properly. Here's what that costs: $500 to $1,200 on a failed session, a judge making decisions about your kids who doesn't know them, and a year of uncertainty while you wait for court. So in this video, I'm showing you exactly what happens in FDR, the 1 preparation step that changes everything, and the 3 mistakes you need to stop immediately. Let's jump in. First, let's cover the basics. What is family dispute resolution? Also known as FDR, family dispute resolution is Australia's formal mediation pathway for separation disputes. An accredited FDR practitioner helps you and your former partner negotiate agreements on parenting arrangements and sometimes property division, all without going to court. Here's the part most people miss. If you have a dispute about your children's care, the Family Law Act requires you to make a genuine effort through FDR before you can file for parenting orders in court. Unless you're exempt, you can skip this step. Now let me show you the math of not preparing. A typical FDR session costs between $150 to $300 per hour, and most sessions run 3 to 4 hours. If you walk in unprepared with no parenting proposal, no clear boundaries, and no idea what you actually need versus what you simply want, you'll burn through that session achieving nothing. Then what? You get a certificate saying FDR didn't work, and now you're looking at family court. Court applications cost thousands in legal fees, take 12 to 18 months minimum, and you've handed decision-making power to a judge who doesn't know your kids. All because you didn't spend 2 hours preparing before that first FDR session. So what actually happens in the room? An FDR practitioner is neutral. They don't decide your case. They don't tell you what's fair. They help you negotiate. Their job is to create a safe space for both parties to explore options, test trade-offs, and document agreements that work for your family. And here's what surprises most of my clients. You often don't sit face-to-face with your ex for hours. Many FDR sessions use shuttle mediation, where you are in separate rooms and the practitioner moves between you, carrying offers and counter-offers back and forth. This is especially common when there's high conflict or safety concerns. The practitioner might start with a joint session to explain the process and ground rules, then separate you. They'll ask each of you, what are your goals? What matters most for the kids? Where can you be flexible? And what can you agree on? Then it's all about covering 2 main things: parenting arrangements, where the kids live, time with each parent, holidays, decision making, and potentially property arrangements, splitting assets, selling the house, superannuation. You stay in control of the outcome and nothing happens unless you agree to it. If you do reach an agreement, the practitioner documents it clearly. You can then take that to a lawyer to turn it into consent orders, which makes it legally binding. If you don't reach agreement, the practitioner issues a Section 60I certificate, which allows you to file for court if needed. But here's the critical part. There are exemptions. If there's family violence, child abuse, or urgent safety concerns, you may not be required to attend FDR at all. The law recognizes that mediation isn't safe or appropriate in every situation. If that's you, get legal advice immediately before booking FDR. Now here's the preparation strategy that saves FDR sessions and the one basic thing mediation advice completely misses: the needs versus wants filter. I've watched this single framework turn a 4-hour screaming match into a 90-minute signed agreement. Without it, couples spend the entire session defending positions they don't actually care about, while ignoring the 2 or 3 things that actually matter. Using the needs versus wants filter, you'll know exactly what you are protecting and exactly where you can trade. Listen carefully, because this could be the difference between walking out with a workable parenting plan or burning through the session, achieving nothing, and ending up handing your kid's schedule to a stranger in a black robe. Before you walk into FDR, sit down and write 2 lists. First list, needs. These are non-negotiables that protect your child's well-being or safety. Example, the kids need to stay in their current school, or changeovers must happen in a public place because of past conflict. The second list should be your wants. These are preferences, but you could live with alternatives. Example, I want Christmas Day every year, or I want the kids with me every weekend. When you get to FDR, you protect your needs and trade your wants. This is how deals get made. If your ex wants Easter and you want Christmas, that's a trade. If they need Wednesday nights because of their schedule and you need Friday nights because of yours, you've just solved two problems. The practitioners who see the best outcomes all say the same thing. Bring a written parenting proposal. That means not demands, but a good starting point. Show you've thought about school holidays, birthdays, communication between visits, and how you'll handle changes. This proves you are negotiating in good faith and makes the practitioner's job easier, leading to faster progress. Now, let me protect you from the 3 biggest mistakes that sabotage FDR sessions. Mistake number 1, negotiating from emotion, not reality. I've seen people walk into mediation still furious about that affair, the betrayal and the lies. Here's the hard truth. Your ex might have been a terrible partner, but if they are a good parent, your child deserves a relationship with them. The FDR practitioner doesn't care about the relationship drama, they care about what's best for the kids. If you spend the session venting, you'll get nothing. Mistake number 2, using kids as a bargaining chip. You might say something like, you didn't pay child support this weekend, so you don't see the kids this weekend. That might feel justified, but it's not. Australian court treats parenting time and child support as separate issues. Withholding access because of money damages your credibility and hurts your child. Don't do it. Mistake number 3, refusing to document communication. If there's conflict or safety concerns, use third-party tools like the Family Wizard app. It's designed for separated parents. Messages are time-stamped, can't be deleted, and are admissible in court. If your ex sends abusive or threatening messages, the app can filter them before you see them, protecting your mental health. Don't rely on regular texts when things can be deleted or manipulated. The bottom line is that you should always walk in prepared. Stay focused on the kids and protect your boundaries. One more thing people worry about is whether what they say can be used in FDR or against them in court. When FDR is conducted by an accredited or authorized practitioner under the Family Law Act, everything discussed is confidential and not admissible in court. This is designed to let you negotiate freely without fear. However, other types of mediation outside the FDR framework may not offer the same level of protection, so confirm your practitioner's accreditation. If you don't settle during FDR, that's okay. You'll get a Section 60I certificate which lets you apply to court if no exemption applies, but even a partial agreement helps. Maybe you agree on school holidays, but not week-to-week time. Try to document what you agreed on, as it speeds up court later and shows you tried to compromise. Now that you know how FDR works, the next question you're probably asking is, what if my ex isn't following the parenting orders we already have? That's where enforcement, contravention, and recovery orders come in, and I've covered exactly how those pathways work in this video. But if you want personalized help preparing for FDR, or you're not sure whether mediation is the right step for your situation, book a free 15-minute strategy call with our family law team. The link is in the description below. We'll help you figure out your next move and what to document before you walk into that room. Your outcome in FDR improves when you're prepared. Get advice early, show up with a clear plan, and keep your kids at the center of every decision. I'll see you in the next one.